Chapter 3 discusses criminal law and how it's applied. We're going to talk about the different sources of law. We're going to talk about the difference between civil cases and criminal cases. Today, our laws govern just about everything we do. Our criminal law is found in statutes. They call that substantive law. This is the crimes: murder, rape, arson. It's outlined in a statute. There's another component of the criminal law system. It's called criminal procedure or procedural law. And this is how things get done, how evidence gets into trials, how the police do their investigation, how a law enforcement should conduct a search, how they should conduct an interview or an interrogation. That's what criminal procedure is about. We'll touch on that. There's civil law, things like, I like how they have the word torts in there, and you might be like, what in the world is that? Civil law, think breach of contract. Torts is also a civil law. Think of car accidents, negligence. You know, those attorneys on the billboards call 1-800-LAW-1010. Those are the folks who are handling negligent cases. And then there's administrative laws. And these are governed through our administrative agencies, our state agencies and our federal agencies. I'll talk a little bit about them in more detail in a little bit. These things also can intertwine and overlap with each other. So we'll discuss that too. But we got to discuss the history of criminal law. And never in time has there never been no crime. Crime has always existed as long as there's been people. And the first body of law, the Code of Hammurabi from the Babylonian time, basically the gist is an eye for an eye. Homicide is killing with malice, meaning you have ill will towards somebody and you plan and you kill them. Homicide in New York today has like 59 different versions of it in the statute. But nonetheless, then from there we had the Mosaic Code of the Israelites. Okay, well, yes, 10 Commandments, right? But you can see that that's kind of even codified in today's law. Thou shalt not kill. We got laws involving not killing people, not stealing from people, right? Adultery is still a crime technically. So those things have some influence on our laws. We're not really going to talk about monetary. That's civil action, but there certainly was some civil cases that took place in historic times. But we're more concerned with the criminal law process. So let's kind of delve into the next layer, our common law, and just to distinguish from what I call church law, those 10 Commandments. And this was developed in England as a single law system. And the common law, it has evolved, with judges, and it's worked out with judges and jurists at the time. And after consideration of many cases involving similar facts, you see a common pattern. Judges tend to look back to past cases to determine what they would do in the particular case they're looking now. So it builds predictability and consistency in the law. We call that precedent, or stare decisis. Let the decision stand. Stand by the decided cases. It actually means let the decision stand in Latin. The legal principle requires that judges base their decisions on local customs and rules of conduct. And that is still what we recognize today. We can look at laws today and we still follow common law. We do not in the criminal law sense. Everything is written, is statutory, which we're going to go to in a little bit. But you have to know that this common law exists and it exists relative to our constitutional law, which we're going to talk about. So this is developed over time, hundreds, thousands of years, decisions handed down, and it creates a body of common law, which still exists here today. In America, we follow the common law in a number of areas. So, precedent, very important. When you see stare decisis, think precedent, which means courts follow the cases that have been previously decided. Okay? Sources of our criminal law, the American legal system, they certainly evolve over time. They don't remain this. These are our laws, and that's it. Don't kill. Don't commit arson. Don't commit rape. Obviously, those types of crimes I just named off have come from the common law, and they have evolved into statutes, and they get expanded upon. I just told you that New York recognizes 59 different versions of homicide. There are many different types of what rape is defined as. There's many different types of what arson is defined as, and it's set forth in statutes. But think about it. Think about a law, maybe you're too, depends on how old you are, but in my case, here's some examples. When I was growing up and I was young, I could sit in the front seat of my parents' car. I could sit on my dad's lap while he was driving. I could stand up in the front seat. I could ride my bike without a helmet. People were able to drink and drive. There was no DWI laws. Could drive a car. I could drive a car when I was 16. I could drive a car and not wear a seatbelt, right? Now everyone wears a seatbelt because it's the law. So they evolve. Laws evolve over time. They also work backwards too. I mean, there's states who are legalizing marijuana possession. New York was one of them when it used to be illegal. So they're always changing. That's the point. We're always changing just to evolve with the time. But also judicial rulings. Courts can deem laws unconstitutional, and they're no longer enforceable. We'll talk about a couple of those. Those are usually deemed under the constitutional component of this discussion. So, common law, we just discussed. Criminal laws, we gave a little background, but I guess I wanted to tell you a little bit more about statutory law, but I don't have a slide for that. I don't think. I'm going right into constitutional law. But let me make one more point on the statutory law. The statutory law is created by legislators, bodies of, our elected officials, whether it's local, state, or federal. The federal criminal laws are created by Congress. The state criminal laws by our own House, our Assembly, which is our House, and our own state Senate, then ultimately passed by the governor. And local laws. There's local ordinances. The city of Plattsburgh has its own version of laws. So you have to know that those are out there. And also there's different areas of law. We have our penal code that houses our street crimes, murder, rape, theft, the ones that we're going to be talking more about here, but also the statutes in other areas like our New York State's public health law. That's where we can find some of our drug laws, like it's illegal to grow cannabis. It's, that's actually when you are violating any rules relative to COVID, you are charged under the public health law. The Environmental Conservation Act governs our laws protecting the environment. So the Vehicle and Traffic Law houses crimes involving traffic, DWI. So we can find those statutory laws in a whole lot of places, but what you got to know is that they are written by the legislators. Oh, Sorry guys, I'm one slide ahead on that. I got to talk about constitutional law, and I can't kick back when I'm recording. So let's talk about constitutional law. You can just sit back with your eyes closed and listen up. Where do you find constitutional law? In the Constitution, right? You're more familiar with the federal Constitution. But there is also a state constitution, and a city charter is considered a constitution that governs the city or the municipality to which it is written. So the protections, the criminal protections that we have, all those amendments, we have 27 amendments in all, but the first 10 ones are the ones that we're going to be paying close attention to. Those Bill of Rights, right? Is that what they're called, the Bill of Rights? That houses several of the statutes that affect criminal procedure and some criminal law. Another topic I want to talk about relative to constitutional law is this concept of bill of attainder. A bill of attainder is an act of a legislator declaring a person or group of people of a crime and then punishing them without a trial. That is something that had happened early colonial America and in England, and the founding fathers specifically wrote in the Constitution, Article 1, Section 9, Paragraph 3, provides that no bill of attainder or ex post facto law, we'll talk about that in a second, will be passed. So the important concept is this is a law that this provision of the Constitution doesn't allow legislators to punish people or allow legislators to impose the law. They took that out of that branch of government. Right? It's the judiciary now. So very important. Ex post facto law punishes an individual retroactively. Why is that bad? Because it's not fair, right? Think about it. If the definition of ex post facto law is a law that applies to crimes that happened before the law was passed, so if a law is passed in 1994 that applies to acts that occurred in 1989, like how do you know that you're actually going to do something wrong, right? Kind of puts everybody on notice. So that's why we don't pass laws and then, oh, by the way, we're going to make sure that they run retroactively. No can do. And this only applies to the criminal laws. Only applies to criminal laws. If legislators create civil laws, they can apply them retroactively. Only applies to criminal laws. And it only applies to legislative laws. So if a court decides that they want to toss a case out as unconstitutional, then it doesn't apply retroactively. Okay? One quick note on administrative laws, real quick. Administrative agencies. Example of those, the Federal Trade Commission, the Securities Exchange Commission, the Environmental Protection Agency. These folks are tasked with prosecuting crimes that fall under their radar or their jurisdiction is the fancy word. So if there is a business that is engaged in deceptive trade practices, the Federal Trade Commission is going to step in. If somebody is committing securities fraud, the Securities Exchange Commission is going to come in. If anyone's illegal dumping, putting chemicals in our waters, our drinking waters, the Environmental Protection Agency is going to step in. So we covered common law, statutory law, constitutional law, and administrative law. They all house criminal law, and they all have some effect on the criminal justice system. All right. Civil law versus criminal law. I promise I won't click the slide. Need to distinguish between the two. Our civil law. Let's start with the civil law. I have a list for civil law and I have a list for criminal law. Civil law. Our parties in the case are called a plaintiff and a defendant. And in a civil case, let's say it's a car accident, okay? Because everyone can kind of relate or even if you haven't been into a car accident, you can relate. Somebody runs the red light, crashes into somebody coming, and the person who was crashed into is injured. So now they want to be compensated. They sue the other driver, plaintiff, okay? And they're suing the other driver. They are the defendant. And if the plaintiff wants to sue the defendant, they have to pick a court. So they go to a lower court. They pick a court, and then they have the defendant served with papers. And once court gets rolling, and if they get to a trial, the plaintiff has the burden of proving that the defendant was negligent, that he wasn't looking when he ran the red light. And that burden of proof is called preponderance of the evidence. It's a fancy little term. And if I got a scale, picture me holding my hands up like a scale, one on each side, and one's tipped a little higher than the other, slightly higher. You put a couple coins in it, boop, it tips down a little bit. That's what the plaintiff has to show. 51, let's say 51 to 49%. Let's do it that way. That's what the plaintiff has to show to win. At that point, the defendant is required to respond. If the plaintiff has done that much and the defendant doesn't say anything, the plaintiff wins. But the defendant has a chance to say something. And if they tip that scale back the other way, 51-49, then they most likely will win. There's no right to a jury trial. There's no right. You actually have to pay for it in a civil case. And if there is a jury, the decision is majority. The majority of the jury would have to decide. So if there's nine people, the majority, right? 5-4, majority. And if the defendant is responsible, if the jury says, yep, defendant did it, the defendant is deemed liable. And the jury awards money to the plaintiff. Defendant's liable, and you get $1 million, plaintiff. The jury does the award. Okay? These are the key points, the key differences. You can line them up slide by slide. Let's look at the criminal list, but these are the key differences. Criminal law. It's the government versus the defendant. You can call them the people of the state of New York, the people of the state of California. You can call them the United States if it's a federal case versus Smith. You can call them the prosecutor, if you like the P word, prosecutor, people. But it's always going to be the government. In a criminal case, they are the ones that prosecute it. They're the ones that bring it in versus the defendant. And then the defendant's arrested by police. The police arrest them. And they go to court. And if the case isn't resolved through one of those informal processes we talked about, the burden of proof is on the government, and they have to prove beyond a reasonable doubt. Beyond a reasonable doubt. You guys have all heard that in all the cop shows. Beyond a reasonable doubt. Now picture my scale. That is way up high, and the other end is way down low. That's the burden, and the defendant's not required to do anything. They're not required to prove a thing. They have a right to remain silent. They do not have to take the stand, and that fact cannot be used against them. So the defendant doesn't have to do anything. The defendant has a constitutional right to have a jury hear their case, and a constitutional right to have a unanimous decision, not this majority thing, 5-4, unanimous. And if the defendant is the loser, they are found guilty, not liable. And it's the court that imposes the punishment. It's a punishment. And it's supposed to send a message to society not to do this kind of crime, and it's also supposed to deter the defendant from continuing and doing that kind of conduct. So that is the key distinctions between civil cases and criminal cases. And the question I'm going to leave you with is, can a civil case and a criminal case arise from the same circumstances? And the answer is yes, they can. So let me give you an example. OJ Simpson. We've all heard of the OJ Simpson case, even if you weren't around when the trial was going on. But he was arrested and tried. His trial was 366 days, and that's just the trial. It wasn't any of the hearings and everything that happened before it, and every single day was televised. If you're really interested in it, there's a YouTube channel that has everything from beginning to end. It's kind of fascinating. But I did watch it. I was alive back then, and I did watch not most of the trial. But anyway, sidetrack. So he's arrested for murdering his ex-wife and her friend, right? And there's a trial. It's a criminal trial. And at the end of the criminal trial, he's found not guilty. And I don't mean to let the cat out of the bag. I think everyone kind of knows that, right? Found not guilty. On the heels of that, the families bring a wrongful death civil case against OJ Simpson for the cause of the death of his ex-wife and her friend. And they win in the civil case. Millions of dollars. So how is it that in the criminal case he's found not guilty and he walks away, and out of the same circumstances in a wrongful death case, in a civil case, he's found liable? It all turns on that burden of proof. The burden of proof. It's very easy to prove a civil case, 51% to 49%, than it is to prove beyond a reasonable doubt that somebody committed a crime. So take that distinction with you, but they can certainly go hand in hand.